Hi everyone, welcome to Beyond the Evidence. This is the channel where justice matters. My name is Marv. I am a true crime fanatic, and I love to dig deeper into the mysteries of unsolved cases. Join me as we search for missing persons, uncover the clues in unsolved murders, follow along with jury trials, and we'll be a voice for the voiceless. I'll share with you the facts, the theories, the clues, the evidence, and the controversies that surround these cases. This is Beyond the Evidence.
What up, YouTube? Facebook, Twitter, Instagram, Snapchat. Marv fans. Or wherever the hell you're watching from. What's up, everybody?
You're watching Beyond the Evidence and True Crime Investigates.
And the Indiana Supreme Court. Yeah, welcome, everybody. The Indiana Supreme Court issued its opinion today. Marv's been dying to see this.
Oh, time.
She's like, I want to see the opinion. I want to know why. Why? Here it is. This is why. So
you know me so well.
I know. It's because, well, we've all been so interested in this case. So what actually happened in this? So there's a news article that came up that I can kind of briefly talk about, I guess, to kind of update as to like an overall of what it says, or we can watch the video, or it's up to you guys. What do you think?
Why don't you just do a general overview?
So the general overview is basically that the Supreme Court justices, in their ruling, they ruled that the Judge Gull, lacked the authority to remove Allen's counsel, but the attorneys could not get a fast and speedy trial because they never filed for it at the time. And that Justice Slaughter, who you guys will see down below in the ticker down there, is one of the justices that was actually moving to remove the attorneys in the first place at the Supreme Court hearing. So he was not for removing them. He was for not reinstating them. Yes. So,
yeah. Okay.
Because of their actions did constitute some sort of negligence. And they said that the judge did nothing wrong. Him down there. The judge did nothing wrong in her attempt to remove them. It was procedural error. She didn't have the authority to do it, but she had to make a decision, and she was put into a tough spot where multiple leaks had happened and she had to do something, and that's the way that it found necessary at the time. And so that's the way that the court is allowed to operate.
Now, in there, didn't they also say that Judge Gull was not to be removed?
Judge Gull is not to be removed, and it was proven that there is no, they did not prove any kind of bias against Richard Allen on her behalf or any kind of corruption. There's nothing that they alleged in the complaint that was proven. They determined that there was nothing like that.
So now the newer motion to remove the judge should just get dismissed or denied based on the Supreme Court opinion.
And it did. And she did deny it based on that. So they filed a motion to disqualify her. She filed a motion to, where she basically said denied. Okay, you're denied. And then they have an attorney, David Hennessy, who ironically, I mean, have you looked up David Hennessy?
No, but he was their attorney the last time.
Yeah. And when you look up attorney David Hennessy, he is, hang on. This is crazy, dude. This case just keeps getting crazier and crazier.
I know.
anybody that's ever looked this up, David Hennessy, Indianapolis lawyer arrested for OWI. And it's got his picture right there. Okay. And he was arrested in July 2018. David Hennessy was, for a drug alcohol or a blood alcohol content that was above the legal limit on July 4th. Interesting, huh?
Yeah.
So in the Supreme Court documents, it discusses that the reason that they gave their ruling, and in their ruling, they discuss that they had basically never come to a situation like this before. And that is the type of thing, ladies and gentlemen, that creates precedence and creates case law. There will be a case law now that people can cite saying State of Indiana versus Richard Allen.
Yep.
To me, that's just, I don't know. This case has generated a lot of different changes in the whole world and the way that laws operate and things like that. Why do you think that they're talking about maybe taking this to federal court at this time?
Taking what part to federal court?
Well, that's what I was talking about earlier. So that news interview I was talking about has a guy on there where they're talking about that this could go to federal court.
As far as trying to remove the judge?
As far as like contempt hearings and stuff like that, if the state doesn't back off.
I'll be right back. Hang on.
Okay.
I forgot to tell my husband something.
Okay. So, like everybody, like what do you guys think? Do you guys think that, I'm clueless here on what's going on in this case. This case has generated so much public interest into it, and it's got my attention to where I'm like, what is going on in the Delphi case? So like, let me look up. If you go to YouTube and you type in Delphi murders, you get a whole bunch of stuff. But accusations of attempt, new request for dismissal. We got a whole bunch of different stuff that's going on. But I think that if we watched a segment of Court TV's new thing, that could really talk about some stuff.
Yeah.
The intro part. Can we watch the intro part of Court TV?
Yeah, go for it.
Okay. Let me pull that up. I'm going to share that to everybody. In case you guys didn't see this, this is good information here.
I just want to say hello to everybody that's coming in late. You didn't miss much yet.
Nope. You didn't. Oops. You didn't miss much. We're basically, go ahead and fill them in on what's going on.
So finally, the Supreme Court opinion has come out, and basically they said that the judge did not lack the authority to remove Rozzi and Baldwin. They denied the 70-day speedy trial because their attorneys, Richard Allen's attorneys, never filed it. And they denied removing Judge Gull. So earlier this week, we had a motion to remove the judge again, this week or last week. That has been denied due to this opinion by the Supreme Court. And we're just tonight we're gonna talk about what's in that opinion and what's happening with this now.
Yeah, and so we're going to take a look at a Court TV segment that kind of brings us over to what also goes along with this opinion. I don't know why, man, but I think it's going to be like glitchy.
Uh-oh.
I got the little 1 bar thing.
There are many dates in a lifetime that you're going to remember. The date your children are born, the date you're married, the date you buy a first house, the date Abby and Libby went missing. One of those dates was last Friday, October 28th, 2022. At that time, we had gathered evidence, and the judge did find probable cause for an arrest of Richard Allen. This investigation is far from complete.
As Mr. Allen is now without counsel, I've ordered him transported back to the Department of Correction. Obviously, without counsel, Mr. Allen's hearing cannot proceed.
What's your reaction to the fact that his counsel withdrew and he wasn't even in court today?
Very disappointed. It doesn't seem to be much of a surprise.
Welcome back to Closing Arguments. We have new documents in the case against Richard Allen. He's accused of murdering two young girls, Abigail Williams and Libby German, back in February of 2017. And since then, this case has been anything but typical. The defense claims their client did not commit these heinous crimes and murders. They say that the murders were part of a ritualistic killing. Allen's defense points the finger at an Odinist cult, and they've hinted that members of the prison system and the law enforcement there in the area, that they're actively involved in the conspiracy. These are all allegations. And today, those accusations continue. The defense filed new documents now alleging that there are two interviews that are crucial to the case of key witnesses that they say were recorded by law enforcement and then taped over by law enforcement. So they've been deleted. The interviews were with a father of a boy that Abby Williams, one of the victims, was dating at the time. And another was a man who was a friend of that man, who the defense claims, along with the boy's father, are both known Odinists. Prosecution turned over discovery to the defense, including a letter cataloging the evidence that the prosecutor was turning over, and it revealed that the boyfriend's father's missing videotaped interview and the second man's missing interview, if one existed, were due to a DVR problem error discovered on September 20th, 2017. All recordings up to February 20th, 2017 were recorded over. And the defense argues this is especially negligent.
Yep.
Oh my God. You can't tell me that no other police department in the United States or in the world has done that.
You know what?
It's more common than you think.
That's part of why I wanted to play this interview, is because there's three people on panel here, and the conversation that these three people generate it goes right along. I mean, it's common sense, and these people kind of say it the best. The lady in the middle here is kind of more on the opposite side of what I'm thinking, and I think that you guys will see that. But like, they talk about that specific thing, and people are, how important is screwing up these documents, right? How important is recording? It's not just Patrick Westfall and Brad Holder. Brad Holder is the father of the boyfriend. Okay. Logan. Now, how everyone's over, not just theirs.
Right. So how can the defense, the defense is just playing into all of the conspiracy theories that are out there.
That's what YouTube,
Like
that's why
they did this on purpose.
They're using YouTube to do it.
Yes, that's
crazy.
Dumb.
Well, I mean, it's smart on their behalf. I mean, look at these comments.
On their behalf, but okay, so somebody has to come online and say, this is actually more common than you think it is. It happens all the time.
Well, let's take a look and see what they say about it.
All right.
As those interviews took place 3 days after the murders, this long unsolved murder case. Still with me to talk about all this, Daryl Cohen, Molly Parmer, Meg Strickler. This gets weirder and weirder the more things that we hear from the defense. Is this just zealous representation, or are you starting to believe some of the things that they're alleging?
I believe very little of what they're alleging, but let's take a look at this for a moment. When our defendant was first arrested, he was big, and now he's little. He's now emaciated. I think that plays into the defense theory, whether they realize it or not. As the jury looks at him, and they're going to say, I hear the evidence, because nobody actually saw anyone do it. It's circumstantial, which means nobody saw it, but it happened. And so they're going to look at him and say, could he have really done it? And I think the prosecution needs to just paste pictures of him when he was arrested so that the jury doesn't look at him as a little old person who just couldn't do it.
I mean,
Prosecutors do that.
the physicality is not the issue. I believe this. I mean, here's the thing. Those of us that love what we do, that love criminal trial work, it's because the truth is stranger than fiction. These kinds of things come out in criminal trials all the time. And as wild as this initially sounded, we all, when we first were covering this case, thought, odinous? What is an odinous? And then we found out that correctional officers that were in charge of him in the jail were odinists. And now we find out that 2 very serious, very important interviews that police conducted were mysteriously recorded over. And these were odinists? At what point do we say, this is too much? It's the same thing as like the circumstantial evidence that we talk about. At some point you put it all together and you say something is here. I think he's innocent. I think it's an Odinist cult murder, and I think it's wild.
And what I was thinking about with evidence, when you're talking about this, the circumstantial evidence, I think about it with like a brick wall, and you're just putting brick on brick on brick on cross-examination, that you pull out all of these facts, and it's in closing argument, you put it all on a PowerPoint or whatever you want, all of these bricks, and say, here, jury, it's not my burden to prove anything, but just take this back when you deliberate and say, have we proved reasonable doubt? And there are a lot of bricks and they keep coming.
And it's not just a Saudi defense. They're not just saying someone else out there, you find it, prosecutor and police did it. They're saying we have a pretty good idea of what this all was. And I want to ask you specifically about these interview recordings, because this murders that happened in this area, this had to have been one of the biggest cases that they'd ever dealt with. So
the only big case they've ever dealt with. I want to emphasize that.
I was going to say, you don't hear anything else about anything in Delphi except for this case.
It's the only thing that's happened that's significant.
Right.
Yeah.
And it's just crazy.
It is crazy. And so like I disagree with the lady in the middle. Lady or the guy on the right, I disagree with him. And then the lady on the very left, I agree with her based on what she says, kind of what's coming up here, this next part here.
The idea that just 6 days after these interviews would have been taped over or lost or destroyed, that's the allegation here, is that the prosecution destroyed it. Does that raise any more red flags if there's an argument that it was an accident?
Doesn't bother me. Why doesn't it bother me? Because the people that were interviewed were available. If they were dead, then it would bother me. If they're available to be re-interviewed, even though their memory may not be as good as it once was.
Well, let me add something to your point, Daryl, because in that defense filing that's described as a known contradiction is that the father of Abby's boyfriend, that at one point he told law enforcement back in 2017, so this might be in the written portion of that interview, that he never met Abby Williams, and she was reportedly dating his son at the time. Then when he was re-interviewed after all of this unfolded in 2023 with the arrest of Richard Allen and all this attention on the case, he told law enforcement after he was interviewed for about 39 minutes that he barely even knew that girl. I met her once. So what the defense is saying is that there's this one material and highly relevant contradiction that exists, and therefore it's plausible that there are many other contradictions that they would have if the defense had that information. But
is that really a lie, though?
You can't tell me that the ISP, the FBI, and Carroll County and Delphi law enforcement didn't really look into this onus theory, because we know they did. They had 2 detectives looking at it. If they had any evidence of this being true, there would have been an arrest a long time ago.
Yeah, they would have pursued that option. They investigated Keegan Kline. They investigated other people. Okay.
Right.
In along their investigation. If they thought that they were the person, they could flip this defense in any which way they want. Right? They could have
go after Ron Logan.
They could have went after Ron Logan. They could have went after Daniel Nations. They could have went after Keegan Kline. They could have went after other people that looked more like the suspect instead of make up something about the going with the Odinism angle that's going to confuse everybody, because it does create reasonable doubt. It does.
I know it does. The only thing I can pray for is that whoever lands on this jury can take all emotion out of the equation and specifically look at the evidence that none of us know what's coming out. So they're the ones that are going to see and hear everything, right? All the pictures that we're not going to see, that kind of stuff. So the only thing I pray for is that as a group of individuals, they take emotion out of the equation whatsoever, and they just look at the evidence.
What if it's someone that supports Richard Allen and is like, I'm going in there and I'm screwing this. This jury's over with, dude.
Oh, and that's what I'm afraid of.
It's possible.
Oh, it's absolutely possible.
And it's possible the other way around as well. I mean,
yeah, exactly.
He's guilty. I'm just going to hand it down no matter what's said in here. I'm going to vote guilty. It is possible.
And guilty of crime by Jay. We're going to talk more about the jury tomorrow night when I have my live on Delphi. I'm kind of hitting on there a little bit tonight, but there's going to be a big discussion on that. Yeah.
Okay. I want to finish out these last 2 minutes.
Yeah.
Okay.
Because of their accusations that the state was negligent in not preserving that evidence. So does that change your position?
The word is no, and it's spelled N-O, not K-N-O-W.
Molly.
I mean, what more do we need to say? That this is incredibly suspicious. If the state is not transparent, that should be the first red flag. And then when you have this blatant inconsistency about whether he even knows the girl, and at first he's denying having ever met her, that's another red flag. And then now he's an Odinist, that's another red flag. I mean, at some point, we can't just blindly look to authority and assume that the state is always going to be doing the right thing. Corruption happens. This is an example, I think,
Can I
of
be
that.
devil's advocate just for fun?
Please.
There are many
this lady right here. I know this lady right here. I like this response.
Many cases that I'm sure all three of us have had, and you hear on court TV, where things are lost, deleted, audio problems, technological issues. It's a very normal kind of happenstance. In
the interviews?
Yes.
All the interviews?
I'm just being devil's advocate just to kind of spice things up here. So you could argue, since they are still available, and that inconsistent statement that he made is not that inconsistent. You know, this is a 14-year-old girl. I have a 15-year-old girl. I don't know what's going on in her life with respect to everything, because you're dating at that level is not that big of a boyfriend-girlfriend kind of thing yet.
Exactly.
17, 18, 19, 20, as they get older, it's a bigger thing. He's laughing because he's got that age.
Could this father have tried to distance himself then if he knew his son was dating her?
I'm just trying to argue devil's advocate that these things happen and it's not enough to be problematic, because they can still give commentary of what they know in 2023. I barely met her. That's like, you know, not a stringent, inconsistent statement.
See? It's not that big of a deal. What he said?
No, it's not. I don't know all my kids' friends.
Okay, so you could easily say, I don't know, I've never met that person. But then find out that, oh, no, wait a minute. When your son's like, okay, hey, mom, like, no, you do know who that is. He was here that one night. Yeah, you remember that one time? Oh, yeah, I do know who that is.
Yep.
Same concept. It was probably like that, ladies and gentlemen. She's 13. Okay, it's not like she was driving over there and hanging out with the dude on a regular basis. It might have been like he saw her in passing somewhere. Okay.
I mean, come on. We all remember what it was like when you were 12, 13, 14 years old. You didn't have a serious boyfriend. You called him your boyfriend, and you know, that was about it. It wasn't a true, well, I can't say a true boyfriend and girlfriend relationship, because things have changed since I was that age, but I don't know.
There are no true boyfriends and girlfriends these days.
I just think it's a bunch of hogwash. What would have been sus to me is if only Holder and Westman's interviews had been taped over.
Westfall?
But it was everybody's.
Yes. Yeah, but they're only emphasizing the two. They're only emphasizing two, the defense. The defense is only saying, oh, two.
Right. But what I'm saying, if it was just those two, I would be like, oh, yeah, that is suspicious. But it was everybody's.
Yeah. I would be really upset about that. Because then it does kind of point, that they were negligent. And the defense at this point, I think they're just grasping at straws for any possible solution to end this case in his favor. And it's just not working, and it's not going to work. Remember what I told you? I thought that the judge would grant a continuance for his attorneys. She did grant it.
Yeah.
So the hearing for the contempt is not set till March. I mean, they could take this to federal court, is what I'm saying. I saw a video earlier, WRTV on Delphi.
I think they would be dumb to take it to federal court.
They could.
I know they could, but get on with the trial, man, to see what is out there.
That's what they're saying. They're saying that the state is causing these delays by trying to ask for the defense to be held in contempt. And I'm saying, no. The state is not.
Some major errors.
The state is trying to get this case on the road to prosecute this dude to get it done and over with. But the defense keeps filing stupid shit against the judge, saying, we want the judge out of here because she denied our motion. Guess what, ladies and gentlemen? That's the way life works in Indiana. Defendants don't win cases generally, and defense attorneys don't win cases generally. And Rozzi and Baldwin should know that, being attorneys in Indiana. They know how this system works. Okay. And they're just on the wrong side of it this time.
Right. And judges don't have to hold hearings to deny motions.
Yeah, so people are like, you are denying, or you can't do that. She can just say, no, denied, bam, no hearing. That's just the way the law works. And if you think that that's wrong, that's just the way it is. There's nothing we can do about it. Whether it's wrong or not, it's the way it is.
Keep an eyes peeled. There's nowhere to pull a judge from because she's not going anywhere.
No,
and
the jury.
Where is the jury? Southern Indiana, isn't that right?
No, Allen County, where she's from, where the judge is from.
Oh, God.
The jury is being sequestered from Allen County, which is where the judge has been appointed from. Who appointed the judge? Someone asked. The Supreme Court, the Indiana Supreme Court appointed the judge.
Was it them or the general?
Supreme Court.
Supreme Court did?
Yep. Supreme Court did. I learned all that when I went through the whole timeline of everything. The Supreme Court appointed Judge Gull, and the Supreme Court backed Judge Gull and said she wasn't biased. So the defense claims to disqualify the judge and their other claims are without merit. They've already been discussed, and they keep filing the same things over and over again. Like, well, we want the judge kicked out. They already ruled.
Guilty of crime, Jay. We're going to talk about that tomorrow night, too.
That's a YouTube channel that covers other crimes as well, a new one. So you want to,
Guilty of Crime by Jay?
Yeah.
Awesome.
Jay, you want the channel?
I need to subscribe to that one, yeah. You know me, I like to watch everything, Delphi.
It's everything.
Except, not everything.
Well, not everything. Yeah, not everybody.
Not everybody.
No, for sure.
I'm too busy watching the Adam Montgomery case right now.
Well, yeah, you know what? I can understand that. I was into that when it first started. I'm not a trial watcher. I am more of I'll update you what happened, but I'm not the one to sit there and watch it all. You know what I mean?
Yeah.
Yep.
No, I gotta watch it.
You gotta watch it. See. Now,
if I miss a part because I'm in a meeting during the day at work, I gotta rewind it and watch it later that night. I can't help it.
are you going to be, have you ever been to a jury trial?
I got called for jury once, and the guy didn't show up. So then I was sent home, and I wasn't called again after that.
Really?
Yeah. I'm waiting for the next time. Awesome, guilty of crime by Jay.
Mm-hmm. So, okay, so do you think that the trial will be in October?
God, I hope so.
I do too.
I wish it was
Are you going to go to the trial? Are you going to go?
Huh?
You going to go?
I would probably have to say no. That's why it better be televised.
No, it's probably, they're shooting for probably 3 weeks, they think.
That's it?
It'd probably be longer, but they at least put out for 3 weeks at least at this time.
With it being such a small courtroom and me being in Wisconsin and having to come the beginning of October for Tabitha's stuff, I would say no, I won't be there for the trial. But I'm going to watch it.
I see. I'm definitely going to be there probably for the trial. I'll be streaming it, watching it. I'm going to try to figure out how I'm going to do it all at once. I'm hoping that it's going to be hard, but I'm going to try to do it all at once. Somehow, some way, I will have it live and be there at the same time. I can't miss this, man. I've waited for 7
Carol, I was thinking the exact same thing. She says, at Marv, when both defense and prosecution find out you run True Crime Channel, I doubt you'll be selected for a jury. I know.
Yes, only if you've covered the case. But I guess the defense may not want, they may or may not want you. I don't know. I don't know if I was a defense person, I may not want someone that covers true crime on my side. You never know.
Yeah. So are we going to go through? Do you want to read some of this?
Do you have it? Okay.
Oh my goodness, I better not get the hiccups now.
What's up, everybody? So if you are not in tune with what's going on, so basically the Supreme Court issued its opinion. It's nothing changed. Nothing changed because of this. This is just the opinion on the order that was given to reinstate attorneys Baldwin and Rozzi back on the case and to lead the judge on the case. So what I'm going to do is pull this up on a bigger, there we go.
I did it.
You did it.
You did it. Yeah. Get used to the buttons. Oh. So this is what an opinion from the Supreme Court looks like.
An opinion.
Decided February 8th, 2024.
Today.
Opinion by Justice Moulter. Chief Justice Rush and Justices Massa and Goff concur. Justice Slaughter concurs in part and dissents in part with separate opinion.
Which means that he didn't agree with all of it.
Mm-hmm.
What didn't he agree with? We're going to find out.
So it starts with Justice Moulter. And it says, now they give you kind of a synopsis here. The state charged Richard Allen with 2 counts of murder because he couldn't afford an attorney. The trial court appointed public defenders Andrew Baldwin and Brad Rozzi to represent him. But after about a year, the special judge presiding over the case became concerned they were not representing Allen effectively. So she disqualified them over Allen's objection, replaced them with 2 new public defenders, and continued Allen's trial for at least 9 months so that his new trial attorneys would have enough time to prepare. Allen was retained 2 appellate attorneys who filed a verified petition of writ of mandamus in our court, requesting that we mandate 1, Baldwin and Rozzi's reinstatement as court-appointed counsel. 2, that Allen's criminal trial begin within 70 days after we issue the writ. And 3, that a new special judge replace the current special judge. The special judge and attorney general both opposed the petition, and we held an oral argument. After considering all parties' excellent written and oral submissions, we granted Allen's request to reinstate Baldwin and Rozzi, but denied his other 2 requests in a short order with this opinion to follow. Here we explain our reasons for those 3 decisions. In short, we reinstated Baldwin and Rozzi as Allen's court-appointed counsel because the trial court did not find that their disqualification was a necessary last resort after weighing the prejudice to Allen. We denied Allen's request for a trial within 70 days because he did not make that request in the trial court. And we denied Allen's request to replace the special judge because he did not overcome our presumption of impartiality by identifying facts showing clearly that the special judge is biased or prejudiced. You want to read the
facts and procedural history? In February 2017, 2 teenage girls, Abigail Williams and Libby German, were killed in Delphi, Indiana. 5 years later, in October 2022, Allen was arrested and charged with murdering them. The trial court judge transferred Allen to the Department of Corrections for his safety while he awaits trial, and then recused from the case. A special judge was then appointed. And then, because Allen couldn't afford an attorney, the judge appointed Baldwin and Rozzi to represent him at public expense. But a year later, the special judge lost faith in their ability to assist Allen with his defense effectively, so she ultimately disqualified them as counsel. A leak of confidential case materials, including crime scene photos, triggered the disqualification. Baldwin and Rozzi represent that in August 2023, one of Baldwin's friends and former employees, Mitchell Westerman, visited Baldwin's office, secretly copied discovery materials, including crime scene photos, and distributed them to others. After discovering the leak, Baldwin and Rozzi notified the special judge and the prosecutor on October 6th. They also explained that after Westerman told Baldwin on October 9th what he had done, Baldwin and Rozzi relayed that information to the prosecutor the next day. 2 days later, the prosecutor emailed defense counsel and the special judge informing them that the individual to whom Westerman allegedly provided the materials committed Xing of himself hours after refusing to answer questions from an Indiana State Police detective investigating the leak. The special judge responded to the email by expressing that she was deeply concerned that Mr. Allen's defense is being compromised by all these recent events. And then directed defense counsel to stop working on the case until the judge could discuss the recent developments with the parties during an October 19th hearing. In the meantime, Allen wrote a letter to the special judge informing her that he had discussed the leak with Rozzi and the impact it could have on his defense, but he wanted Baldwin and Rozzi to continue representing him. Counsel for both sides met with the special judge in her chambers just before October 19th hearing to discuss the court's expectations for the hearing. During that meeting, the special judge informed Baldwin and Rozzi that they had demonstrated gross negligence and incompetence, and conveyed that she had grave concerns about the representation of Allen. In support, the special judge said the attorneys failed to safeguard confidential case materials, including crime scene photos, emailed confidential work product to an unauthorized person, and failed to timely report the leak, made extrajudicial statements about the case, and included inaccurate statements in various pleadings. Based on these concerns, the court informed counsel that she had decided to disqualify Baldwin and Rozzi, but she offered to let them save face by withdrawing from the case so she wouldn't have to go into a public hearing a few minutes later and read a statement that she had prepared explaining why she believed counsel was grossly negligent and ineffective. Allen wasn't present for this discussion, but after briefly speaking with Baldwin and Rozzi, he relayed through them his objection to the court's disqualification. Since the court presented to Baldwin and Rozzi what seemed like a Hobson's choice, withdraw or be disqualified in a public humiliating fashion, they conveyed that they would withdraw over Allen's objection to the court's disqualification decision. The special judge accepted their withdrawals and conducted a brief hearing without them. where she stated merely that there was a, quote, unexpected turn of events, and defense counsel had withdrawn from the case. But after having a few days to reconsider and discuss it further with Allen, defense counsel changed their minds, and neither Baldwin nor Rozzi ever filed written motions to withdraw as required by Trial Rule 3.1. Instead, Rozzi filed a verified notice of continuing representation, notifying the court that he, in fact, would not be moving to withdraw and would continue representing Allen. And he filed a motion to disqualify on behalf of Allen, arguing the special judge was biased and should recuse herself. The trial court struck both filings in the court and ordered the clerk to remove them from the record because Rozzi was no longer counsel of record. She also appointed 2 new public defenders to represent Allen. Baldwin then filed a motion to reconsider, also informing the court that he would not file a motion to withdraw. He did not consider his oral withdrawal effective, and he would continue representing Allen. And Baldwin and Rozzi both entered new appearances as Allen's, privately retained pro bono counsel. But after hearing on October 31st, the court entered an order stating the special judge previously found gross negligence by Baldwin and Rozzi in their representation of the defendant, and nothing has changed in the interviewing 12 days that removes the court's grave concerns about this representation. Over the strenuous objections, the court disqualified them from representing the defendant and affirmed the appointment of new public defenders. The court also continued the January 8th trial date to October 15th, 2024. On November 6th, 2023, Allen petitioned his court for a writ of mandamus by original action and asked us to, number 1, 3 things. Order the trial court to reinstate Baldwin and Rozzi as court-appointed attorneys. Number 2, order Allen's trial to begin within 70 days after the writ was issued. And 3, replace the special judge. We heard oral argument on January 18th, 2024, right here on Beyond the Evidence and True Crime Investigates, and we issued a writ later that day granting Allen's first request, but denying the other 2. And the discussion is?
I can read that if you want.
Go ahead.
So the discussion, as we explained below, we agree with Allen that he's entitled to have his original court-appointed attorneys reinstated. But we agree with the state and the special judge that Allen is not entitled to a writ ordering a trial to begin within 70 days or replacing the special judge. 1. Allen's request to reinstate his original court-appointed counsel presents extraordinary circumstances warranting relief. Allen argues the trial court exceeded its authority by disqualifying his original court-appointed counsel because disqualification was unwarranted and significantly prejudices both his defense and his opportunity for a speedy trial. The state and the special judge respond that the original action is not the proper procedural vehicle to evaluate Allen's claim. And even if it was, the special judge was within her authority to disqualify counsel because she was rightly concerned that they were not fulfilling Allen's constitutional right to effective legal assistance. We agree with Allen. Our court has repeatedly reviewed attorney disqualification issues through original actions, and we do so here because Allen's petition presents the sort of extraordinary circumstances for which there's not an adequate appellate remedy that our original action rules require. A. We may review an attorney disqualification decision through an original action. This court has exclusive original jurisdiction to supervise the exercise of jurisdiction by all Indiana courts. Original action rules. We exercise our supervisory authority through original actions for writs of mandamus or prohibition. Each writ is an extraordinary remedy, equitable in nature and viewed with disfavor. A writ will not be issued unless the relator can show a clear and obvious emergency where the failure of this court to act will result in substantial injustice. It will also be issued only where the trial court has an absolute duty to act or refrain from acting, and original actions may not be used as substitutes. One issue our court has repeatedly reviewed through original actions is whether to disqualify counsel. Issuing a writ to disqualify a special prosecutor because the prosecutor's relationship with an attorney against whom the defendant has recently testified created an appearance of impropriety. State ex rel. Jones versus Knox Super. Declining to issue a writ to reinstate court-appointed counsel, the trial court disqualified for their insulting and absolutely improper comments because the attorneys had affirmatively requested that they be allowed to withdraw if the trial court denied their request for continuance. Then they said State L. Myers versus Tippecanoe County. Declining to issue a writ requiring the trial court to withdraw an order disqualifying the elected prosecutor, where the elected prosecutor was a defense attorney for the accused in 2 prior cases. They go on to cite Marion County, what is that, Sendak versus Marion County?
I wouldn't even read all those if you don't want.
Okay.
Those case laws, I would skip those.
Okay. As in the prior cases, reviewing the trial court's disqualification decision here is appropriate through an original action. That is because the case presents extraordinary circumstances where denying a writ will result in substantial injustice, and Allen's petition is not a substitute for an adequate appellate remedy. We reached that conclusion for a few related reasons. For starters, disqualifying Allen's counsel delayed his trial by at least 9 months, and the trial court has already concluded that Allen's pretrial confinement presents extraordinary challenges. Normally, criminal defendants who must be confined while they await trial are detained in the county jail with other defendants who are awaiting trial or who have been convicted and receive shorter sentences. But here, for Allen's safety, the original judge transferred Allen to the Department of Corrections, which runs our state's prisons, facilities that generally detain inmates only after they are convicted and serving longer sentences for more serious crimes. The special judge later reconsidered the original judge's transfer order, and she too found it reasonable and necessary to ensure the defendant's safety and to prevent seriously bodily injury. Allen is being held at the Wabash Valley Correctional Facility, which is hours from Carroll County, where the charges were filed, and Allen County, where the special judge serves. Allen's original public defenders and his substitute public defenders have all challenged the condition of his pretrial confinement, including as they relate to preparing his defense. We are in no position to evaluate the claims in those motions, and the special judge has concluded at least some of Baldwin and Rozzi's claims about the confinement conditions are wrong. But even assuming every aspect of Allen's pretrial confinement is proper, and again, we are in no position to say one way or another at this point, extending it for at least 9 months still presents extraordinary challenges for which there is no adequate appellate remedy. What's more, as we explain in greater detail below, we've concluded the trial court lacked the authority to remove counsel without, 1, considering other less drastic options, 2, weighing the prejudice to Allen. So not only would Allen's trial be delayed for at least many months and his original attorneys were not reinstated. If Allen were convicted, correcting the disqualification by vacating his conviction and ordering a second trial would produce years of further delay and an enormous waste of time and resources that would not serve anyone's interest, not Allen's, not the state's, the victims' families, the courts, nor the public's. Of course, these concerns can generally be resolved through discretionary interlocutory appeals. Let's see here. And both the state and the special judge argue that it is the procedural route Allen should have pursued instead. But Allen effectively couldn't, which is another reason this matter is extraordinary. On top of disqualifying counsel, the special judge struck their later filings because they were no longer counsel of record. Without the ability to file a motion requesting the special judge to certify her order for interlocutory review, Allen's attorneys couldn't pursue that avenue, requiring trial court certification to pursue a discretionary interlocutory appeal. To that point, the state and the special judge responded that Allen should have had either his new public defenders or the appellate attorneys he retained for this original action pursue an interlocutory appeal instead, but it isn't clear how either option was feasible. The newly appointed trial counsel had nothing to do with the disqualification proceedings, and Allen wasn't present for them, so it is not obvious how Allen would work with his new trial attorneys to pursue an interlocutory appeal in the trial court. Maybe Allen's privately retained appellate attorneys could have done so, but it is unclear whether the trial judge would permit them to represent Allen in the trial court along with his new substitute court-appointed counsel. And it is unclear how it would work if substitute court-appointed trial counsel disagreed with the privately retained appellate counsel about whether to seek certification in the trial court.
I can read if you want.
Let me just finish this a little bit.
Go ahead.
We simply don't expect Allen to untie that procedural knot, and he can cut through it with his original action instead. Our prior precedents pointed appellate counsel to the original action tool, and we declined to retire that tool for these sorts of situations now.
Okay, so having concluded that Allen's petition is properly before us, we turn to its merits. B, Allen is entitled to the reinstatement of his original court-appointed counsel. Number one, court-appointed counsel may be disqualified only as a last resort after considering the prejudice to the defendant. The Sixth Amendment to the Constitution, to the U.S. Constitution, to the 14th Amendment's Due Process Clause, and Article 1, Section 13 of our Indiana Constitution guarantee criminal defendants the right to have an attorney assist them with their defense. That's U.S. Constitution Amendment 6. I'm going to skip down through this, and it says, for defendants who can afford to hire an attorney or retain an attorney to represent them for free, that constitutional guarantee includes the right to choose an attorney who will represent them. Okay. It says this choice does not extend to criminal defendants who can't afford an attorney who can't find one to represent them for free. Allen can't afford an attorney, and he asked us to reinstate Baldwin and Rozzi as his court-appointed counsel. Consequently, he has no constitutional right to choose which attorneys will represent him. But he didn't choose. I want to remind everybody that he has no constitutional right to choose which attorneys will represent him as court-appointed counsel. But he didn't choose Baldwin and Rozzi. The trial court did. The judge did. Mm-hmm. Judge Gull did. Allen just wants to continue with the attorneys the trial court chose for him. He is insisting on the continuity of his counsel rather than his choice of counsel. Courts and the country are divided over whether Sixth Amendment guarantees criminal defendants in continuity of court-appointed counsel. I'm going to skip through this. For example, the Colorado Supreme Court recently held there is no Sixth Amendment right to the continuity of a court-appointed counsel. It still acknowledges that a defendant's interest is continued representation by a lawyer that they have been working with is entitled to great weight if they can demonstrate that prejudice would result in the substitution with different court-appointed attorneys. The court concluded that the interest flows from the due process guarantees the 5th and 14th Amendments to the U.S. Constitution rather than the 6th Amendment's right to counsel. And while the U.S. Supreme Court has not yet addressed whether there is a 6th Amendment right to continuity of a court-appointed counsel, it too has recognized that the rights to due process and counsel overlap. The Colorado Supreme Court also recognized that before disqualifying court-appointed counsel, the court must determine that any remedy short of disqualification would be ineffective. While the state defends the disqualification here, it appropriately acknowledges that a trial court's discretion to disqualify court-appointed counsel is significantly limited. The state's brief accurately explains that while varied interests may necessitate overriding a defendant's preference, disqualification is an extreme remedy that should only be used when a court deems it reasonably necessary to ensure the integrity of fact-finding process. The fairness or appearance of a fairness at trial, the orderly or efficient administration of justice, or public trust and confidence in the criminal justice system. The Attorney General was the Attorney General's response. So whether a product of a defendant's right to due process or the right to counsel, the bottom line is this: a trial court cannot disqualify court-appointed counsel over the objection of both the defendant and appointed counsel unless a disqualification is a last resort.
You have your own copy that you're reading from, right?
Yes.
Okay, I'm going to go to the bathroom real quick.
Okay. Disqualification is necessary to protect the defendant's constitutional rights to ensure the proceedings are conducted fairly and within our professional ethics standards, or to ensure the orderly and efficient administration of justice, if those interests outweigh the prejudice to the defendant. Okay, and it goes on to say that disqualification here was not a last resort. The special judge concluded Baldwin and Rozzi made 4 mistakes that demonstrated that they may be unable to assist Allen in his defense effectively. They failed to secure confidential case materials, including crime scene photos. Baldwin misdirected an email, says he inadvertently with confidential case materials to a non-party client without timely reporting the mistake to the trial court or the prosecutor. Baldwin and Rozzi made extrajudicial statements while the prosecutor's motion for a gag order was pending, which the special judge thought might prejudice the case. And 4, statements of Baldwin and Rozzi's motion to reconsider safekeeping order turned out to be wrong. Respondent's brief, 12 through 15 pages, but the record does not reflect the special judge disqualified counsel only as a last resort after bowing her effective assistance of counsel concerns against the prejudice to Allen that would result from substituting counsel. Okay, now I'm going to skip through here. So what you're seeing on the screen is not what I'm reading. I got a different thing, but Marv's got a page pulled up right now. So I have a poll on my channel. Do you think that the Supreme Court should have removed Baldwin and Rozzi? Take that before all this started happening, this new stuff. Now, first, the record does not reflect that disqualifying counsel was a last resort for the special judge's concerns could be addressed through a combination of procedural rules and court orders, including the gag order and protective order she entered. And trial courts maintain both statutory and inherent authority to compel compliance with their orders and the procedural rules through contempt proceedings and sanctions, which is where we're going through now. So what they said right here, trial courts maintain both statutory and inherent authority to compel compliance with their orders and procedural rules through contempt proceedings and sanctions, which is what the prosecutor has filed for now, a contempt proceeding, which was postponed. Someone asked that earlier. The order states as follows as far as the contempt hearing. It says that an order was issued. The defendant's motion for contempt hearing scheduled for February 12th, which was next week, reviewed and granted without hearing. So they filed for continuance. It was continued to March 18th, 2024 at 9 o'clock in the morning in the Allen Superior Court in Fort Wayne, Indiana. And the court will reissue a transport order for Richard Allen to show up at that time. Okay. The only basis for disqualifying counsel was a special judge's concern that they cannot assist Allen with his defense effectively. But they found out that they are more than qualified. They have over 30 years experience representing thousands of clients around the state, including clients charged with murder, sex crimes, robbery, burglary, and other violent offenses. Has tried more than 125 jury trials. Rozzi has over 25 years of the same, including 3 murder trials and previous certification to handle death penalty cases. Moreover, neither the state nor the special judge argue that counsel's extrajudicial statements or the statements in their motion harmed Allen's defense. They do argue the disclosure of case materials undermines Allen's defense, but they don't explain how. And they don't argue these mistakes reflect that Baldwin and Rozzi are incompetent to handle Allen's defense or explain why disqualification is necessary to protect Allen's right to effective assistance of counsel. Notably, neither the state nor the special judge direct us to any case concluding that issues like this, either in isolation or combination, rendered counsel constitutionally ineffective or were sufficient to warrant disqualification. Third, there is no showing that the special judge's concerns outweighed the substantial prejudice to Allen from substituting counsel. Baldwin and Rozzi spent a year working with Allen, investigators and experts, developing Allen's defense, and Allen saying he's ready to present it to the jury. The prejudice to Allen begins with the fact that the information and momentum spillage is inevitable, as one trial team hands a complicated case like this over to another. And to that, Allen has already been in jail for almost a year and a half now. And substituting counsel requires 9-month delay in the trial date, with substitute counsel unsure whether they would even be ready by then. That is not surprising, given that this is a complicated, high-stakes case. Further, it has already been 7 years since the murders, and the fact-finding only gets harder as time passes. Memories fade, and evidence is lost. Because the record does not reflect disqualification was a last resort, and after balancing the trial court's concern against the prejudice to Allen, Baldwin and Rozzi must be reinstated. Allen's remaining request, no extraordinary circumstances warranting relief. Allen's second request is that we mandate the trial court order order the trial court that Allen's trial to commence within 70 days. Allen and his attorneys prepared and signed a speedy trial motion, but they never filed it with the trial court. Until a trial court has refused to rule properly, there is no basis for relief on this court. Okay, so that they couldn't order that. Wherefore, we deny Allen's request to order that this trial begin within 70 days, although his attorneys remain free to make such a request in the trial court if Allen wishes, and they haven't done so. They were screaming for it.
Why not?
Because they're not ready for it. They were just using it for a leg to stand on.
Gotcha.
And Allen, you know what? And Allen's third request is that we appoint a new special judge to avoid the appearance that the trial court is biased against the defendant. But Allen has not stated facts showing clearly that the special judge's disqualification is required. We begin with the presumption that a trial judge is unbiased. That's what the presumption of innocence, right? We go in there saying the trial judge is unbiased at this point. To overcome that presumption, the party seeking disqualification, which is Richard Allen, must identify facts reflecting that the judge's actual bias or prejudice. Our law is well settled that prejudice is not inferred from adverse judicial rulings, meaning it's not prejudice if you deny someone's motion. Okay,
and
that's what that means.
Butthurt about it.
Yeah, that's not prejudice because you deny motion. This happens all the time. For the people out there like, she's denying it because she's prejudiced. This right here is a case law that backs up that that's not true at all. Okay, Allen identifies here the special judge's adverse ruling disqualifying counsel. No doubt that the adverse ruling was significant, but nothing in the record suggests the special judge's decision emerged from bias or prejudice against Richard Allen. Just the opposite. The special judge explained that she disqualified counsel because she was trying to protect Allen's right to the effective assistance of counsel. And we don't minimize her concern. We don't minimize her concern. I want to repeat that. She faced a significant dilemma giving her conclusion that the defense counsel were no longer effective. If she left counsel in place and Allen was convicted, the conviction might have been vacated through post-conviction proceedings based on ineffective assistance of counsel.
Snarky, hang on. Snarky says it is if you don't have a hearing to hear things out. That's wrong. She doesn't have to have a hearing.
That's the thing, is everybody's like, she didn't have a hearing. It's not required to. They don't do that in Indiana. They just deny motions. They don't have hearings for shit. Yeah, they don't. Everyone that thinks that that is supposed to be, they don't do that at all for anything. They just say yes or no.
It's not a process or procedure that a judge has to have a hearing to hear a motion. Okay.
All right. So where were we at? All right. So it says right there too, if she left counsel in place and Allen was convicted, everybody, the conviction may be overturned or vacated, which means he let out because of an ineffective assistance of counsel claim. Because they did those things, he could have raised an appeal and won. He could have. Okay. It might have been vacated because she infringed on Allen's right to continuity of counsel of choice. She was in a tough spot either way, it says. Though we've determined records does not support her disqualification decision, we've reached that conclusion with the benefit of the weeks to consider the issue. Thorough briefing and oral argument from the excellent appellate attorneys and the benefit of 5 justices and their staffs poring over the record, authorities, and arguments. The special judge did not have those luxuries. Nor does Allen point to anything suggesting the special judge is biased against Baldwin and Rozzi. Of course, she said their mistakes reflected gross negligence, and she was concerned their representation was ineffective. But judicial remarks during the course of a trial that are critical or disapproving of, or even hostile to the parties or their cases, ordinarily do not support bias or partiality challenge. The Supreme Court citing this. That is, unless they reveal an opinion that derives from an extrajudicial source or reveal such a high degree of favoritism or antagonism to make fair judgment impossible. The special judge said counsel made mistakes that rendered their representation ineffective, but her statements were not based on extrajudicial source or any experience outside this case. Instead, her statements were based entirely on her observations within this case. And while her conclusion that counsel were constitutionally ineffective was too harsh, she wasn't wrong to deeply concerned that the sensitive case materials had been leaked. Though she mistakenly hit defense counsel's eject button instead of the case lockdown button, she was right to try to get the situation under control quickly and decisively. Her efforts did not reflect any bias or prejudice, and Allen does not identify anything she has done that demonstrates she isn't impartial. Wherefore, we therefore deny Allen's request to replace the special judge. And having granted Allen's request to reinstate his original court-appointed counsel and denied his remaining requests through January 18th, 2024 court order, this opinion terminates the original action proceeding in this court. Petitions for rehearings or motions to reconsider are not allowed. And that's it. Right? And then what, you have one more part, Slaughter. Slaughter has something to say at the bottom.
Yep. So Slaughter says, Relator Richard Allen fails to meet the demanding threshold for obtaining the extraordinary relief he seeks. He establishes neither that respondents breached a clear legal duty entitling him to an unquestioned right to relief, nor that an ordinary appeal would provide an inadequate remedy. Thus, I concur with Part 2 of the court's opinion, which denies Allen's request that we replace Special Judge Frances C. Gull and order a trial within 70 days. But I respectfully dissent from Part 1, which orders the reinstatement of Allen's court-appointed counsel, Andrew Baldwin and Bradley Rozzi. My objection has less to do with the court's legal analysis than with its bottom-line issuance of a writ. Given the procedural posture in which the issue of attorney disqualification comes to us, had this issue arisen in an interlocutory appeal or after a final judgment, I would be more open to Allen's argument that the trial court erred in threatening to disqualify his trial counsel after finding them grossly negligent and incompetent. But that is not the posture of this case. By seeking relief through the vehicle of an original action, Allen takes on the erroneous burden of satisfying its exacting requirements. Original actions are viewed with disfavor and cannot serve as a substitute for appeals. We do not issue writs to establish rights or define duties. A writ is warranted only to force an official to perform a clear legal duty or to grant an unquestioned right to relief. A writ will issue, in other words, only where the trial court has an absolute duty to act or refrain from acting, and we will not intervene if an appeal will afford an adequate remedy. The regular appellate process must be wholly inadequate to compel us to action. Allen falls short in both aspects. First, the trial judge did not violate an absolute duty in dismissing court-appointed counsel because Allen does not have an unquestioned right to keep them. The Sixth Amendment protects Allen's rights to effective counsel, Wheat versus United States, which includes his choice of qualified counsel, Kaplan and Drysdale versus United States. The right to counsel of one's choice, though it is not absolute, but is circumscribed in several important respects. Trial courts have wide latitude to balance this right against competing interests like fairness, our professional ethics standards, and court scheduling needs. The essential aim, after all, is to guarantee an effective advocate for each criminal defendant and not to ensure that the defendant will inexorably be represented by the lawyer whom he prefers. While the trial judge's actions raise a potential constitutional problem, under current law, it is far from clear she exceeded her authority. The court's opinion admits as much. To justify its award of relief, the court must fashion a new rule against which to adjudge the trial court's actions below. A trial court cannot disqualify court-appointed counsel over the objection of both the defendant and appointed counsel unless disqualification is a last resort, b, disqualification is necessary to protect the defendant's constitutional rights to ensure the proceedings are conducted fairly and within our professionals' ethical standards, or to ensure the orderly and efficient administration of justice, and c, those interests outweigh the prejudice to the defendant. And then, having announced its new rule, the court proceeded to find the trial judge breached it. The problem is that this rule did not exist previously. The opinion cites nothing from our court or any court establishing this rule. Yet, despite being unable to identify the source of the rule imposing the supposedly clear legal duty, the court awards extraordinary relief anyway. The court is not even sure. Oh, go ahead.
No, go ahead. Oh. Go ahead and finish that little sentence out right there.
Okay, the court is not even sure of the rule's constitutional source, be it the defendant's right to due process or the right to counsel.
So what they're saying is, okay, everybody, this is new law that's set. So what they're saying is people are like, the judge breached. I've seen someone saying the judge breached the rule. What they're saying is there was no rule in place. This wasn't a thing. This is kind of like we made one up right now. Okay, is what they're saying. They're saying that there wasn't anything that the judge did, but we see that there's an issue here because of this. And so we're going to have to make up a rule and say, okay, a judge can't do this. And since the judge can't do this, we're going to have to say that this judge breached it, even though it wasn't a rule at the time. Now it is. And so that's going to be a case law. That's what case law against Richard Allen is going to be now. So it's going to be state of Indiana or Richard Allen versus Indiana, state of Indiana, and the Indiana Supreme Court of Appeals. It is going to basically say that the trial court right there, right above it, that's the ruling. That's the new case law. A right there. A trial court cannot disqualify court-appointed counsel over the objection of both the defendant and appointed counsel. That's new case law right there.
Right.
That's history. What's written right there, that's their new case law. That's interesting. That's crazy to see that happen. That's brand new. That's a new law right there.
Because of this case.
Because of this case. Because of that certain situation. Interesting. So crazy. You can go on. I just wanted to bring that up to everybody that didn't understand what that meant.
Good.
Yeah.
The existence of such a duty is anything but clear if the court must patch together its rule out of whole cloth to justify today's result. On the merits, I do not necessarily quarrel with the rule the court announces today. It appears to strike a reasonable balance between the competing interests of a criminal defendant's right to counsel and a judge's duty to ensure the defendant receives a fair trial. My beef, rather, is with our after-the-fact application of this newly minted rule to award mandamus relief against Judge Gull, who did not have the benefit of our rule when she acted. For this reason alone, I cannot join Part 1. Our original action rules do not permit issuing a writ when the judge trial duties are unclear or the law is unsettled. Original actions are for clear-cut cases that apply settled law, not for cases like today's that announce new legal rules. The latter is what appeals are for. Second, Allen does not make the case that an appellate remedy would be inadequate. This case could and thus should have been brought as an ordinary appeal. Instead, by issuing a writ, we ratify Allen's improper request for a shortcut to an appeal on the merits. Allen could have sought a discretionary interlocutory appeal under Appellate Rule 14b when the trial judge dismissed his counsel and barred them from entering a pro bono appearance. There is no reason to presume Allen's original action counsel could not have pursued such an appeal on its behalf. And had Judge Gull refused the request and Allen been convicted, he would have had the ultimate appellate remedy: automatic reversal of any convictions based on his claim that the judge's disqualification of counsel amounted to structural error. Either appellate remedy on interlocutory review or after final judgment would have provided Allen all the relief to which he was entitled. Finally, the court rationalized its writ by claiming we have repeatedly reviewed attorney disqualification issues in original actions. In fact, our case law does not bear out a pattern of issuing writs in disqualification disputes. On the many cases the court cites, we issued a writ in only 2. In one of those, we disqualified a special prosecutor whose appointment violated a statute forbidding the appearance of impropriety. In other words, we disqualified an attorney whom a state agency hired in violation of the statute requiring the Attorney General to represent the agency. Unlike here, both cases involved the violation of clear legal right or duty, and but for the writ, the counsel's continued representation would have exceeded statutory authority. The court today flouts our original action rules to award extraordinary mandamus relief in favor of Allen and against the trial judge. In doing so, we allow Allen to short-circuit the appellate process, muddy our own jurisprudence in this important area, and invite future deviations from our rules. In my view, these institutional costs far outweigh the benefits to Allen. For these reasons, I respectfully dissent from Part 1 of the court's opinion and concur with Part 2. He makes some pretty good
stuff. He does have some good points. He does not agree with letting them back on the case, and he's saying because they didn't have that rule in place that the judge didn't really violate anything. You know what I mean? So, I mean, that's what he's saying. So I agree with him the most. I thought he was the most strict person when I was watching him. You know, Slaughter. He's that one guy with the glasses. He's just probably the most strict person that I saw there. I think that looking at this whole thing here, should they have been reappointed in the first place? What do you think? Should they have just kicked him off?
The judge or the Supreme Court?
No, should the Supreme Court, should they have just kicked them off and left them off? Or, you know what I mean?
Based off of what he's saying, yes.
But he was outvoted, so.
Right. Based off of what he's saying, according to their laws and their procedures and processes for the Supreme Court, Andrew Baldwin and Brad Rozzi should have never been put back on.
Exactly.
Now, that brings up the biggest point. So now that they waived the appellate process and they went to the Supreme Court, if he's found guilty, is he able to file an appeal?
Not on ineffective counsel. Remember we went over that and people were arguing about that. Nope. Not on ineffective assistance of counsel.
Because
Not
they jumped over. Okay, so in an organization, a company that you work with, you have a chain of command, right? This is just like following the chain of command. When you go over your manager's head and you go straight to the CEO, you're done for. Whatever their decision is their decision. You don't get to go back down the ladder and redo things the right way.
Check out this poll. Should the attorneys have been removed by the Supreme Court? It's a 50-50 decision.
Oh my goodness.
Out of 40 votes that I put on my channel.
Wow. That's crazy.
That is crazy. It really makes you wonder. So, I mean, so anybody that's listening to this today, this does not change anything, what we're reading. This is just reflecting their decision that they made on January 18th when we were watching them talk live and discuss live the case. And if you noticed in there, wheat, a lot of people talk about wheat, how the attorney talked about how wheat, they cited it. The Supreme Court cited wheat as a grounds for removing the attorneys. So I don't know. This case is pretty cool. It's got a lot to offer as far as information to dig through now. You know, back in the day, we didn't have anything to go off of. Nothing.
Oh yeah.
What do we have now? I mean, now we're digging through. I mean, you got documents on top of documents that we can't even keep them straight.
Right.
As how many documents there are. And then every single day, I was telling my friend Jay, I'm like, dude, or people that I talk to, I'm like, hey, you want to hear the breaking news in the Delphi murders case? And everybody just laughs because it's every single day now.
Exactly.
It's not like, oh, dude, it's 6 months later. Oh, dude, something happened in Delphi. This is every day, every hour, sometimes twice a day. I wonder if Westerman's trial should happen first so the information was out. You know what? His will happen first. I'm almost positive of that. What do you think?
Oh, I agree.
I'm going to do a poll on that on my channel. Who will go to trial first?
Yeah, Westerman or...
Yeah. Westerman or Allen? I want to know what you guys think about that.
I think Westerman's set up a lot better to go to trial first.
I think so too. And that's what I'm looking at Westerman's right now. Mitchell Westerman. All right. So his case is, I'm going to share my screen. Entire screen.
I forget I can't do it from this screen. I have to go to the other one to do a poll.
Yep, you got to go to your Facebook, the actual page itself. Yeah. So let me switch you guys over here. So check this out. So here we are. Here's Mitch Westerman. And if we go down to, here we are. Right now he's set for jury trial. May 14th is when he's set for jury trial. And the latest things that we got going on in his case is my request. On the 29th, Johnson County, Indiana camera in-court request from True Crime Investigates. And
did it get approved?
Here's what's weird. So it says the court and gives the party 7 days from January 29th, 2024, in which to respond to the in-camera request from True Crime Investigates filed with the court. And I mean, we're past 7 days. So, I mean, like they didn't file anything. So they didn't object to it. Either one of them that I'm aware of that's been filed with the court. So the judge hasn't issued an order, but when I get that order, trust me, I will share it with everybody. I'm very interested to see what they're going to say. You know, I'm really interested in what they're going to say. Are they going to grant that? If they grant that, do you know what that would be? That means I would be the first YouTuber in history to do that.
That means we got to find somebody to go to court that day and film.
Oh, believe me.
Chuck Bronson. How you doing?
What's up, dude? You ever watch this channel? Yeah, I thought so. Okay, I plug it a lot. Chuck Bronson, man, he grew really fast doing the cop watch. If you guys like auditing and like following the police around live and stuff like that, he's one of them. He is one of those guys that when you're flipping through TikTok and shorts and you see those videos, he's one of them. Good stuff. Subscribe to Chuck Bronson, please. He is a cool dude. Good friend. And he's a member.
All right.
So what do you think happens now, Marv? So we've got a continued hearing. The judge is saying that she's not going to back off the case. The case is going to be continued, and the contempt hearing is going to be continued until next month or in March.
Lollipop.
Okay.
Westerman has been out of jail since right after he got arrested. Yeah, but he's not in jail. He got bailed out, or he bonded out or whatever.
Yeah. And that's the thing, is that's what I was discussing on my channel, is why would I mean, the contradictions are there. Did the police pick up on that already or not?
Right.
Okay. You know, that's what I'm curious about. And I'm going to check my poll. Take my poll, ladies and gentlemen, if you got it going on here.
Yep, we're going to leave it up a couple more minutes on my channel too. Take the poll.
Yep, take the polls, everybody. Switch back and forth to the channels and take the poll. We're live on both channels in case you guys didn't know that. If you're joining late, we're on Beyond the Evidence and True Crime Investigates.
All right. Remember, hit the thumbs up button, the like button.
Yeah, did you know that? Hey, did you know that when you're looking at your phone on YouTube sometimes and you don't have the chat pulled up and you're just sitting there looking at the video and someone says, hit the like button? Like right now, you guys should look at your phones. Look at your phones right now. Okay, everybody? Yep. Okay, and take the chat off and look where you can see the thumbs up button. Okay. And when I say hit the like button, does it flash on your screen? Does the like button highlight on your actual phone? Because it does on mine.
Yeah.
It does. When I say hit the like button.
Oh, when you say hit the like button, I don't know.
When I say it, yes, when I say it, your phone should light up on the like button itself. I found that's a new feature that YouTube has. Some people may not have it. If you not update your YouTube, and anytime someone says that, it like highlights the like. It's really cool.
Really?
Yeah, see, someone said it. Yes.
That's
I said
so
yes.
cool.
No. Someone said yes. Someone said no. Yep. Yeah. Update your YouTube app, and it's pretty cool. I noticed it the other day when someone said it. They said hit the like button, and it was like,
I'll have to do an update.
Yeah, it's really cool. So, all right. So I'm going to go ahead and end my poll, ladies and gentlemen. Out of 30 votes, I got, what was your answers, or what was your poll?
Should the attorneys have been removed? Oh, no, that was yours.
Here's mine.
Oh, here's mine.
Who will go to trial first, Westerman or Allen? Out of 30 votes, 96% said Westerman. I'm in there too. I'm going to say Westerman.
So I had 4 votes and 100% said Westerman.
100% said Westerman. There it is. Yep. Bam. 100% said Westerman. Who goes to court first? What's up, Dr. Feelgood? It's almost time. So, what are you covering next on your channel, Marv? What's next? The Adam Montgomery thing?
Nope. Tomorrow is Delphi. We're going to have a Delphi discussion on Beyond the Evidence. It's long overdue. People can call in with their opinions. We're going to talk about some pretty important things like juries and what your obligations are. And one of the big things we're going to talk about tomorrow night is, why is anyone right now deciding that Richard Allen is guilty or innocent? Because they shouldn't be.
Because he's guilty.
No, because you haven't heard all the evidence.
I've heard enough.
No, you haven't. Oh.
He owned a blue coat and he's been down a hill. That's good enough for me.
So we're gonna have some really good discussions tomorrow night on Delphi. You guys have all heard about the documents. I'm not gonna reread documents. We're gonna actually discuss and have debates and do it nicely.
Southern style.
We're gonna do it nicely. We're gonna respect you. We're gonna respect each other's opinions and agree to disagree.
I like places like that.
Yeah.
People are welcome to call in.
Yeah, absolutely. I'm going to do call-ins. You can join us.
Cool. Okay, so I'll spread the word. We want people to call in. Just call in and be respectful. Voice your opinion. If you think, listen, I did that video about the power of suggestion where I talked about people going with the crowd because they don't want to feel stupid or out of place. And I can't reiterate enough that on my channel, and I know on our channel, your opinion is valued and welcome. You're welcome to come and talk to us and tell us what you think without feeling like you are going to be scrutinized in any manner. And if people in the chat try to scrutinize you, we'll correct them. So your opinion's welcome. You don't have to conform to the crowd. If you think something that's the opposite, I love it. Zavgirl thinks the opposite. Marv and I think the opposite about a lot of stuff.
Oh, yeah.
You know?
So the live is called Delphi Case. Will we ever get justice? And it's 7 p.m. Central Time, 8 p.m. Eastern.
There it is. So it's 7 p.m. Central Time, 8 p.m. Eastern.
Yep.
Which is 5 p.m. Pacific Time. Anybody that's Pacific.
You got to figure that out. I have a hard enough time keeping track of Central and Eastern.
I'm 3 hours behind Eastern Time, 2 hours behind you. I know. It's easy to figure out. So there you go, ladies and gentlemen.
Once again, I'm going to let everybody know. And Jinx, I know Jinx has been throwing the link out in my chat. Beyond the Evidence has a Patreon page.
There it is.
Because of the new YouTube restrictions and guidelines about what we can talk about. I'm going to do general discussions on YouTube, and I am going to do very in-depth and give specifics on Patreon because I won't get demonetized on Patreon. So it's $5. You can do a free membership for 7 days to see if you like it. And right now I've got all kinds of stuff on there about Jennifer Crumbly's trial and now Adam Montgomery's trial. And I will be putting things on there about Delphi starting this weekend. So
about Delphi?
Yep.
Okay.
You know how much stuff I have on my computer when it comes to Delphi.
You know what? I am the same. Okay, so my computer's totally full. I mean, it's so full I have to delete stuff to add stuff. And it's almost all Delphi, dude. Literally. It's crazy. I can't believe it. I need a new computer. Everybody want to donate to a new computer?
Here it is. If I didn't have this, I'd be in trouble. And I know you have one. External drive to save everything on because I filled my computer a long time ago.
Oh, all these are filled. I got an external drive. My computer's filled. The external drive's filled. The other backup hard drive's filled. I'm going to
have to get another external.
I'm going to have to get another computer with everything on it. I mean, basically, I just need an upgrade, a better one. that'll be that'll be what my donations get saved for, everybody. If you guys want to help donate to a computer, they're like $300 for the one I want. It's not nothing fancy. It's just got more storage. That's what we need, storage. You know? Oh. Then we can clear this one up.
Oh my goodness. Guilty of crime by Jay says, yes, didn't know that.
I'm on Pacific time.
Yeah.
So yeah, so there you go. So Marv's got a Patreon. I don't do Patreon, so there you guys go. And tomorrow's call-in
is so easy to use.
Is it?
For creators, it is so extremely easy. So easy. I can do live stream. Once I get more members, I'm gonna start doing live streams on there and everything else. So,
awesome.
Yeah. And everybody's like, oh, do tiers. No, I didn't do tiers. I did it really simple. $3 a month, you can just support the channel. And then $5 a month gives you full membership for everything.
I see. I'm going to show you guys something. These are some comments that were left on the new stuff going on about the Supreme Court hearing and all the drama that happened today. Basically, this person says, this is just public comments. This is on not my channel or anything like that. It says, this is a shame and a disgrace. Indiana looks like we are nothing but fools. The whole world is watching. There is no justice for anyone here. So embarrassing and so shameful. Where is justice? And then Moonchild says, this has become a clown show and its focus has been lost. 2 little girls got brutally murdered. Where is their justice?
Exactly.
I agree with that. I just wanted to highlight those comments because I thought that whoever those people are nailed it on the head. So
we are getting a storm here.
Are you?
It is February 8th, and we are getting an actual storm. This is the weirdest. I'm sorry to just break out on this weather thing, but this is the weirdest wet winter we've ever had. We haven't even gotten a winter. We haven't even gotten a winter.
I know. I got winter. It's snowed and stuff like that. But I mean, like, the weather's changed since I was a kid. Winter used to start in November. Now it starts in February.
It does not rain and storm and thunder and lightning in Wisconsin on February 8th. Normally, we're still having minus 20 to 30 degree temperatures at this time.
Yeah.
And there's crazy, tornadoes. The only reason Andrea put in chat before, are you close to Rock County, is because there's tornadoes now in Wisconsin. They're in southern Wisconsin. Yeah.
Holy cow.
In southern Wisconsin, but I'm in northern Wisconsin, and Illinois got hit by tornadoes today too.
Can you imagine living in western Wisconsin?
Yeah. There were tornadoes, and yes. I love it, Kay. Blame Baldwin and Rozzi. I'm going to blame them on the weather. The weather is all their fault.
There you go. All right. It was 60. That's nice.
But yes, join us tomorrow night on Beyond the Evidence. We're going to have some good discussions when it comes to the Delphi case.
All right. I'll join you. And then I don't know what I'm going to be talking about tomorrow. I'll be talking about something.
You always
something to do with this case somehow, some way, shape, or form.
Yeah.
I got 2 lives during the day usually, so I'll come up with something, ladies and gentlemen. But I'll be there to see you. Okay.
Yes, and my deepest sympathies to you, my dear, with your grandma passing away.
Thank you. And for anybody that didn't know that, thank you too. For anybody that commented on that video yesterday. I didn't do the live stream because my grandma passed away yesterday. And so that's my mom's mom. And it was kind of unexpected. And so we're all dealing with that. But yeah, definitely that thought.
And if anything hits tomorrow and comes out tomorrow, any updates, we'll let you know tomorrow night.
It will be there. It'll be there. Trust me. I'll probably be talking about it sometime in the morning. It's always there. Follow me on Twitter, everybody. I'm trying to get more Twitter followers. Okay.
Yeah.
Follow me on Twitter. We'll be there. All right. I'm going to jump off here.
All right, everybody. On that note, remember, justice matters for everyone in all cases. Anthony?
And on that note, everybody, I'm Anthony Greeno from True Crime Investigates. Until next time, keep it Southern style, y'all.